Oh, you're just on mute, Sarah.
Rookie error. Thanks, Jen. Afternoon, everyone. Just one quick thing I wanted to mention before we get on with the webinar is that this is the penultimate webinar for this series, and we will be getting together to do the next series starting in September. So if there are any burning issues that you would like to hear about to do with the law, please, and construction law preferably, do let me know. So if we can have the next slide, please, Jen. So today we are looking at smash and grab adjudication, and it doesn't come, much more exciting than that title when you do construction law. So what are we going to be looking at? So we're going to look at payment notifications. So that includes interim payment applications. So applications basically that the party doing the work will submit, payment notices or payment certificates, and pay less notices. And we're going to look at the implication of these being issued and not being issued, which is effectively a smash and grab situation. We're also going to look at some of the case law around this, just to show that unfortunately it has got quite complicated, and some steps for project managers, contract administrators to take to protect themselves. So before we go on, please note that when we're talking about a contractor doing something, I'm also referring to a subcontractor in a subcontract. So equally, when I'm talking about the developer or the paying party, that also covers a contractor in a subcontract. So particularly if you're a contractor, you're going to be looking at this from both angles. So if we can have the next slide, please, Jen. And I think we've probably, so typical construction disputes. So this is just to put the smash and grab in perspective. So probably the most typical kind of dispute is on the contractor's account, the subcontractor's account, or of course it could be consultant's account. And typically that would be dealt with in adjudication, and typically it's in the same way as if you went to court, proving that an item is a compensation event or a variation or whatever, and also establishing the quantification of it, the extra time, etc. So that's what we'd call in that second bullet point a merits claim, where you prove all of your claim and all of the detail to it. Smash and grab is slightly different, which we'll come on to. A defects claim, typically that would be after the defects period has expired, and usually a dispute regarding defects would be dealt with in court or in arbitration, not adjudication. Let's not get our A's muddled. And then probably finally, procurement disputes. So if you're tendering for any public sector work, frameworks with local authorities, hospitals, central government, etc., if you are not satisfied with the result of that tendering process, again, that would be court proceedings. So the smash and grab comes into the category of adjudication, but it's very different to that merits claim that we've just been talking about. So if we can move to the next slide, please. Okay, so a little history lesson. So in construction, we're very special because we have the Housing Grants Construction and Regeneration Act. So obviously it's the construction bit that we're interested in. So it's from about clause or section 109 onwards. It's just a small part of what is a very big act. It was brought in 1996. Some of you probably won't even remember the 1990s, but never mind. And for 10 years, and what it introduced was the right to adjudicate construction disputes, to get the disputes dealt with quickly, the right to payment process, an interim process, rather than, for most other contracts, you pay at the end. If you buy a car, you pay when you pick it up, etc. Of course, construction, that's not really possible. We need to keep the cash flow going. So it introduced the right to interim payments, and linked to that, of course, adjudication to recover payments when they weren't made, and also the right to suspend work in very discrete circumstances, i.e. the same as the smash and grab circumstances. So for 10 years, we had this situation, and basically, with regard to the payment process, it was pretty much what we have now, in that party doing the work would submit an interim payment application, an application for payment, whatever you want to call it. And then the next step was that the paying party would issue a payment certificate, and that payment certificate would be what they were going to pay. But the rule at that time for these 10 years was that if there was no payment certificate, then that meant I'm paying you zero. It's a nil from me. And the only remedy the contractor really had was to adjudicate on the merits. So, you've said nil, I applied for 500,000, I'm going off to adjudication to prove the 500,000. So then if we can have the next slide, in 2011, the Act was amended. So this Act, the Act that amended it, was snappy titles, Local Democracy, Economic Development and Construction Act. And one of the main things here was to change this interim payment process. It was felt by the government of the time that this mechanism, sort of self-defeating, where, if no notice was submitted by the paying party, it just meant that they didn't have to pay anything. So that was reversed, so almost to force the paying party to submit a payment notice. And what we ended up with, therefore, was a system where if the paying party didn't submit a payment notice, there's got to be a penalty for it. So how they dealt with that in this Act in 2011 was to say, well, if the paying party doesn't submit the payment notice to say what it is willing to pay, then what has to be paid is the sum that the party doing the work has applied for. So obviously it assumes that the contractor or subcontractor has submitted an interim payment application. And hopefully you can see what a valuable tool that is to contractors and subcontractors through projects. And so what you ended up with in practice when this Act was brought in would be contractor or subcontractor submits interim payment application. For whatever reason, the paying party would omit, forget to submit a payment notice, and it had a second bite of the cherry, a pay less notice. At which point the contractor would say, well, this new Act says you've got to pay me in full in the sum that I've applied for in my interim payment application. Quite often the paying party would say, oh, absolutely not, I don't want to pay that. Didn't mean to forget, I forgot to submit the notice. I didn't mean to not submit it. And therefore, to get that money, the contractor started an adjudication simply on the lack of the notice. It's slightly more than that, but of course you can see it's not the merits adjudication that we looked at a few minutes earlier, and that was how it. So that's the adjudication that you start. You can see it'll be a lot more simple and speedy than a merits adjudication, and the courts coined the term smash and grab to describe, what this type of adjudication was. So hopefully you can see that this is a risk area for the paying party, so developers, but also sort of project managers and contract administrators, because typically they're the people who submit these payment notices and pay less notices. So they go on holiday, they forget to submit them, quite often they're the ones who are going to have to give the bad news to their client, the developer, to say, actually missed the deadline, not served the notice, and therefore there's a smash and grab adjudication just being started. So if we can move on to the next slide, please. Thanks. So how it works. So we've already seen that there's an interim payment application, payment notice, or sometimes called a payment certificate, and then a pay less notice. And they typically are in that order. So which one prevails? Well, if all three of them are served, the pay less notice. So the pay less notice is the top of the tree, basically, even though it's served last. Then the payment notice, and finally the interim payment application. So whichever one of those is issued, whichever one prevails, is the sum that is payable. So hopefully you can see there that if there's no pay less notice and no payment notice, it's almost right. Well, what's due to be paid? Well, it can only be one thing, can't it? The sum in the interim payment application submitted by the contractor. So there's also, so that second bullet point, the fourth sub-bullet point, you'll see it says contractor's default payment notice. So that can be issued by the contractor, the party wanting to be paid, if either it omits to submit its interim payment application in time, and also the developer fails to submit its payment notice. So the developer, the paying party, still has the opportunity to respond to that, because it can then respond by submitting a pay less notice to effectively trump that default notice. Now, it's not quite that simple. So, we've talked about the hierarchy and which one applies, but as this bottom bullet point says, each must fulfill certain criteria. So if we can move on to the next slide, Jen. And because, if you think about it, the consequences of these notices are quite onerous, quite serious. There's various case law, and I've had several where substantial amounts of money have been payable just for the lack of a notice or notices. £1 million plus. So what we need to make sure is that the notice that we're relying on, whether we're the paying party or the claiming party, that it's a valid notice. And this slide sets out how you ensure that it's valid. If you don't comply with these provisions, then the notice is invalid. So you may as well just chuck it in the bin. It doesn't count for anything. So the first thing is, and this is under the Housing Grants Act as amended in 2011, the notice, whichever one we're talking about, so the interim payment application, payment notice, certificate, pay less notice, contractor's default notice, they must state, number one, the amount due. You would expect that would, you would put that in automatically, but it must state that. And it also must state the basis of calculation, and that must be relatively clear. And there's a little bit of case law on that recent times, so we'll come to that. Next criteria is it must be given at the correct time. So in accordance with the contract, and the contract must be in accordance with the timescales within the Act. So we've got the Act is sort of slightly strange Act in some ways, because in some respects it mandates elements that the parties have got to include in their contracts. And if those mandated elements aren't in, then there's a scheme for construction contracts which applies. But there are other elements where the information's got to be contained in the contract, but there aren't. It's not mandated as to what it has to actually provide. So we'll come to that later. But the notice must be given at the correct time. So this next bullet point, an IPA must be clear that it is an IPA. So that's a case of Caledonian and Mar City. Now, there's an absolutely huge amount of case law regarding these payment processes. This is just one of them. In this case, so this is an authority to basically say things like, if you've used the same format for your IPAs throughout, be really careful about changing the format. If you're going to, my advice would be tell the other party in advance, possibly send a draft of it so that it's absolutely clear, so they're not going to see it and think that doesn't look like, the usual IPA, I'll just ignore it. Because if you think about it, even though it's called an interim payment application, the other documents are called notices, and effectively the IPA may end up being a notice if the other notices aren't served. And the whole purpose of a notice is that you're notifying the other party. So it's not, the aim here isn't to hide what it is, it's to be very clear what the document is that you're submitting. Also, another case, Henia Investments and Beck Interiors. In this case, the court said if your IPA is submitted late, so we've already seen it's got to be submitted within the correct timescales. If it's submitted late for this month, so say it should be submitted by, I don't know, the 26th of May, it's submitted on the 27th, it's not valid because it's not within the correct timescales. In this case, they tried to argue, therefore, that it slipped into the June application. And the court said, no, your May application, again, it clearly says it's the May application, blah, 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 blah. You can't then by some miracle say, oh, well, it's converted into the June application. And it's, partly about being transparent and, making sure that it is a notice, i.e., the other side is easily aware of what it's supposed to be. And then finally, we're talking about notices, and typically construction contracts require notices to be served in a specific way. So sometimes they might have to be either hand delivered, served by first class post. Quite often email isn't a valid method of service. So you just need to be careful about that. So if we can move on to the next slide, please, Jen. Yes, so we talked about the circumstances where you would bring a smash and grab, so where either the party wanting to be paid has submitted its IPA and the paying party hasn't submitted any notices, or party wanting to be paid doesn't submit the IPA. There's no payment certificate issued by the paying party, so the party wanting to be paid submits that default payment notice, and subsequently there's no pay less notice from the paying party. So in either of those scenarios, or alternatively a situation where, for example, payment notice or pay less notices are served, certifying, I don't know, say £200,000 in circumstances where £500,000 was the interim payment application. If that 200,000 isn't then paid, we have the same situation because it should be paid. If it isn't paid, you've got a smash and grab adjudication. Alternatively, you might want to think about threatening winding up proceedings, pretty aggressive. You can also suspend your work. So this is the other element of the Housing Grants Act. Now, be careful here because sometimes people think suspension means, I can suspend at any time, that I'm not happy with something. Absolutely not. It is a very, very discreet remedy. And it's not well used because parties tend to prefer to adjudicate on a smash and grab basis. And I think that's partly because if you suspend and you get it wrong, so for example, you haven't served your notice in the right time scale, so it's not valid. It doesn't state the sum due, it doesn't state the basis of calculation, so it's not valid. So effectively it goes in the bin. You know, in an adjudication, you lose the adjudication and have to pay your own adjudication fees, which you would have to anyway. If you've suspended, you're going to have to bear your own costs of that suspension, and you're probably going to be paying liquidated damages for that period as well. So it's probably a more risky situation. What I would say is if you are going to suspend, I'd take legal advice first, just to make sure that you are entitled to suspend. Sometimes this situation might be a ground for termination. Usually, so with NEC, the paying party has to have not paid for 13 weeks or more. And again, terminating is a bit drastic when you can do a smash and grab adjudication. And then another case here, just to confuse things a little bit. So this is the way this case law rolls with regards to the payment provisions. So this is Galliford Try and Estura. And a substantial award was granted on a smash and grab here. It was about £6 million. And I haven't got the date of the case, but I would say it was probably 2016, a good few years before the pandemic. So, really chunky amount of money to be awarded for the lack of a notice, not on the merits, remember. And what the court said was actually that's a little bit too much. So they awarded about half of it to be paid. In some cases, they might say the balance has to be paid into court. But what the courts are concerned about is, particularly with small businesses, give them £6 million, they then go bust, the money's gone. And the key thing with smash and grab is that it's not a permanent remedy. So you might be successful in your smash and grab adjudication. It's great for cash flow, because you get the money that you've asked for. But the rule is that once that money has been paid over, the party who is dissatisfied, so the party who's paid the money, can then start their own adjudication to recover the money. So you might think, well, what's the purpose of doing it? Well, it's good for cash flow. In some contracts, for example, JCT, there's no ability to claw back money until the final account. So that's, really good for cash flow. Particularly where you are a main contractor, it means that the paying party, who might be a developer or whatever, they're left in a position where they've got to claw the money back. So they have the burden of proof. They've got to prove how much money they're entitled to back, which is difficult for them because it's not a situation they're often in. Usually they're in the position of saying, I'm not going to pay you this. I don't think it's a compensation event. You need to prove to me, contractor, you need to prove to me that it is a compensation event. And you also need to prove, the time and the money that attaches to it. So it's just generally quite difficult. And of course, it's a nice place and an unusual place to be in, from a contractor subcontractor perspective, if you're going into negotiations with regard to the final account, to actually have the money in your possession and to be discussing, well, to resolve this account, we'll give you X back, but no more. So it just changes the dynamic, the burden of proof. So take it from me, it is a valuable tool. Next slide, please. Okay, so this is pretty much what the mechanism looks like. So we've sort of been through this. The contract is interim payment, and going down this left-hand side. We then have a due date, so that's imposed by the Act. And then we have a payment notice. And what the Act says, so this is part of this, the Act mandates some things, but not others. So the Act mandates that the payment notice must be submitted within 5 days of the due date. So if your contract says something different to that, so if it says 7 days, it's non-compliant. And this is where it can get confusing. And I mean, to be frank, if you're operating on NEC unamended, JCT unamended, then you will be compliant with the Act. But some bespoke contracts end up being non-compliant, and sometimes amendments to the standard forms result in contracts being non-compliant. So if it's non-compliant, the default position is that you revert to the scheme for construction contracts, which helpfully for the party wanting to be paid are actually quite short time scales, so more likely to result in a smash and grab scenario where, for example, project managers relying on a contract that extends the timescales for payment, but it's non-compliant for whatever reason with the Act of Parliament. Therefore, the scheme applies, and quite often you'll find that the project manager, the contract administrator, hasn't stuck to those scheme deadlines. So we then have a payment notice, and then between the payment notice and that final one, we have a timescale for the final date for payment. Now, again, the Act says that the date for the final date for payment must be pegged to the payment notice, and we'll see a case on this where the court said that the payment mechanism wasn't valid because the final date for payment was pegged to the contractor, the party wanting to be paid, submitting a valid VAT invoice, and the court said that's not valid. So you would then revert to the scheme because it wasn't valid. And then from the final date for payment, you have the pay less notice, which must be submitted. So with NEC, it's at least 7 days before the final date for payment. So the key is to remember that whatever the period is, sometimes that's amended to 1 day, but it means that if the final date for payment is the 30th, and you've got 1 day, the pay less notice has to be served on the 29th, the 28th, or the 27th. It can't be submitted on the 30th. Ditto if it's 7 days. If it's the 30th for your final date for payment, you can serve your pay less notice on the 23rd or the 22nd or the 21st, but you can't serve it on the 24th, the 25th, the 26th. So that's the process. And on the right-hand side, if a payment notice is submitted, then that immediately, assuming it complies, assuming it's valid, becomes the notified sum, the sum that's going to be paid, subject to what the pay less notice might say, which comes later. So the purpose of the pay less notice, it is thought, is that it comes a little bit later. So you might serve your pay less notice if you're a contract administrator or a contractor in a subcontract, and then a couple of days later find some defects in the work, and you might want to make a reduction to reflect those defects until they've been remedied. So that would go in your pay less notice. Or you might forget, as a contract administrator or contractor in a subcontract, to serve your payment notice, and in that case you get a second bite at the cherry with the pay less notice. Now, of course, the 2 bullet points apply, as we've seen. It must be submitted in the correct timescales and in the correct form, i.e. stating the basis of calculation and the sum due. Next slide, please. Excuse me. So this is a sort of alternative situation. So the left-hand side is the same kind of flow chart, but you'll see we've kind of crossed out payment notice here. So sadly, project manager's forgotten to submit the payment notice. At that point, as soon as the timescale has expired, the contractor's interim payment application is the notified sum, subject, of course, to the pay less notice being issued. Now, if a pay less notice is issued, that's the notified sum, that's the sum that has to be paid. If no pay less notices issued, so double error on the paying party's side, then the contractor's interim payment application prevails as the notified sum, providing, see the bullet points, that contractor submitted in the correct timescales, check, and in the correct form, which is, we know, stating the basis of calculation and the sum due. And also the contract must allow or require the contractor to submit an application for payment. So we know NEC does, both NECs 3 and 4, most JCTs do as well, but that's an extra mandatory requirement that's in the Act. Next slide, please. So this has evolved slightly. So there's no payment notice and no interim payment application. In this instance, we've got a default payment notice submitted by the party wanting to be paid, which would become the notified sum subject to the pay less notice. And the same points apply with regard to the correct timescales, the correct form. So if we can go on to the next slide, please. Yeah, I mean, that's pretty obvious. Yeah, so we've got JCT. I'm not going to run through this, but if we can, so they're just the timescales in the JCT design and build. Sadly for me and for you, if you work on other JCTs, all the JCT contracts and the subcontracts are different. So if we can move on, and I think we've got the timescales, so hopefully this will be a bit more relevant. So this is NEC, looks hideous, but don't panic. It is as bad as it looks, to be frank, but no, we'll run through it and it should be fine. So what we've got, the second box down is assessment date. So that is the pivot, that is the fixed, that's the fixture throughout the contract, from which everything runs in the payment process. And you can see above it is the application, the party who wants to be paid, their application for payment. And what NEC says is that they may issue an application for payment if they choose to do so. They don't have to, but they may. If they don't, this assessment date still occurs. So when is the assessment date? Well, two things. We have an assessment interval. That has to go in the contract data part 1. It could be every 28 days, it could be monthly, it could be every 2 months. Let's work on monthly because it's easy. So let's say the assessment interval is monthly. So contractor, subcontractor knows the payment process works on a monthly time scale. So what's the assessment date? Well, the left-hand side of the slide deals with this. So if, for example, the work starts on the 5th of June, we know our assessment period is 30 days, is monthly. So on the 5th of July, the new assessment period starts. So what the contract says is the project manager, once the work has started, so that was the 5th of June, has to notify the contractor, or contractor notifies the subcontractor in a subcontract, what date the assessment date is within that first interval, so before the 5th of July, which is the start of the next interval. If the PM doesn't do it, then it is automatically the last day in that first interval, which would be the 4th of July. So let's assume that it's the 30th of the month. Obviously, it shouldn't be the 31st because that's going to cause problems because lots of months don't have a 31st. But we'll work on the basis of it being the 30th or the 28th in February. Let's not go into the detail too much. So if it's the 30th, we know that the party wanting to be paid, and it says we've got application at the top of that chart, and to the right it says on or before the assessment date. So application for payment submitted by the party wanting to be paid on or before the assessment date. So application for payment in my example has to be submitted on the 30th of the month or before that date. obviously not too far before it, or it's going to be a little bit pointless because not much work will have been done. We then have the assessment date. We know that's on the 30th for this purpose. And then the chart splays. So the left-hand side is the YUK provisions. So they're the specific Housing Grants Act provisions in NEC. They're in YUK because if you think about it, Act of Parliament in the UK, well, England and Wales, only applies to contracts in England and Wales, in work in England and Wales, and this is an international contract. So in Australia, the YUK is irrelevant. They're not interested in our Housing Grants Act, I'm afraid. So in that case, the clause 50s, so clause 5 of the core clauses on the right-hand side applies. Now, the whole thing actually meshes together. So you'll see where it splays off from the assessment date. We've got the due date, and the left-hand side is 7 days from the assessment date, and the PM's payment notice is a week from the assessment date, so the same day, basically. We then have from the due date, the final date for payment. So remember, the Act requires the final date for payment to be pegged to the due date. So that's 14 days. And then you can see on the other side, the clause 50 says that the final date is 3 weeks from the assessment date, but that works because, of course, the assessment date is 7 days before the due date. So the 14 days and the 3 weeks work together. So from the final date for payment, we work upwards to work out the pay less notice. It's not later than 7 days for payment. So if, and I'm just doing this for the sake of my maths, if the final date for payment happens to be the 27th of the month, the pay less notice has to be served on the 20th or earlier of that month. It can't be the 21st, 22nd, 23rd, etc. So that's the process here. We've got the default payment notice provision in there in the event that party wanting to be paid forgets to do their application for payment, or it's invalid for whatever reason, providing they realise it, and the project manager forgets to do their payment notice. If the project manager puts in a payment notice, then there's absolutely no point putting in a default payment notice unless party wanting to be paid thinks that the project manager's payment notice is invalid for whatever reason. So if we can move on to the next slide, please. So when realistically is a smash and grab most effective? Well, if you think about it, it's not going to be effective in, months 1 or 2 of the project, because whilst the paying party might make deductions, might not pay the full amount of the IPA, by the time you've adjudicated, they're probably onto the second interim payment process, and the sums that were claimed in the first have probably been paid. So where it comes into its own is usually towards the end of the project, and typically where there might be a few disputed CEs or CEs that are agreed, but where the quantum and the time hasn't been agreed, and or variations and EOT loss and expense in JCT. So the difference between what the contractor or subcontractor is applying for and what the contract administrator is certifying is growing. So you've got a big difference. Then all of a sudden, contract administrator forgets to submit their notices, and bingo, contractor or subcontractor is entitled, or consultant entitled to be paid the sum that they've applied for. And of course, it's handy as I've said, for cash flow purposes, but also, you know, it just gives the party who's been doing the work the edge in any negotiations on the final account. But as we said in previously, that final bullet point, the developer can do a counter adjudication on merits, albeit it's got to make the smash and grab payment first, and the party counter adjudicating must prove its claim. So if we can move to the next slide, please. So just some sort of tips as to how the developer or contract administrator can protect their position. Basically, make sure all the dates are clear for all of those processes, and bear in mind, you know, typically you're going to be doing this once a month. Make sure they've been diarised. Make sure, you know, the developer, the paying party, understands them as well. You don't, as a project manager, want to get into a situation where the paying party, you know, is saying, oh, well, I'm not happy with what you've certified, I don't want to pay it, because, you know, that's not a ground for not paying. You know, have pro formas, you know, payment notice and pay less notice to hand, so that, you know, the whole process hopefully runs seamlessly, because, you know, as we said at the start, this is risk area for the paying party and project manager, contract administrator. The last thing you want as a project manager is to be having to say to your client, paying party, that you missed a deadline for a notice, or the notice wasn't valid, and a smash and grab is being commenced against your client. So next slide, please. Okay, so some of the case law. So the first case that, I mean, you will see nothing in the Act, even the 2011 Act, that says smash and grab, but this first bullet point, the ISG and CECA, was the first case, that was 2014, to basically say, yes, this is the implication of not submitting notices. And what the court said here was that if you don't submit your notices, paying party, stroke contract administrator, then you are by implication accepting that the contractor's interim payment application is the correct valuation. The third bullet point deals with the Grove developments, which sort of overturned the earlier ISG case, and said, actually, there's no implied acceptance. This is just what, you know, the Housing Grants Act requires. You know, it's false to say that because I've forgotten to serve a notice, that by implication I accept that I've got to pay the contractor or the subcontractor what they've applied for. So it's, you know, it sort of amounts to the same thing. The penultimate bullet point, the M. Davenport and Greer case, goes on to say that, you know, yes, we support smash and grab adjudication, and the money has to be paid, but once the money has been paid, the paying party can then do their counter adjudication to try and claw that money back, but only once they've paid. New case right at the bottom of 2023, Liddell and Close Circuit, says that if you want to adjudicate following a smash and grab on something totally different, then you can without having paid that smash and grab. But that sort of makes sense. What the smash and grab rule is, you've got to pay your smash and grab money before you can counter adjudicate to recover it. So if we can move on to the next slide, please. And some more case law, and hopefully, I mean, some of this is kind of helpful day to day. Some of it is just to show what a sort of a kind of tangle we've got ourselves into with this. You know, we should be able to say, well, we've got an Act of Parliament, we just follow it. It's not turned out to be that simple. So the next case is a 2016 case, and it's Grove Developments and Balfour Beatty. And in this case, in the contract, they had a payment schedule, which, you know, is really popular, seems really sensible. You know, we have our list of interim payment applications, our list of due dates, so it's all covered through the contract. What they forgot to do, or possibly deliberately didn't do, was to carry on that schedule of payment processes beyond the completion date. And unfortunately, from time to time, construction projects are delayed. So Balfour Beatty went to court and said to the court, look, we've had to work beyond completion. The payment schedule doesn't go beyond completion, but surely it must be implied into the contract that a similar mechanism just follows on beyond completion. And the court said, well, no, sorry, that's not what the contract says. The contract says, and the court took a very literal approach. The contract says your payment process is set out in this schedule, and basically the last date is whatever the date was. There's no way we can imply anything into this contract. And unfortunately, that meant that Balfour Beatty had to wait until the final account process before it could recover any further money. So, that's pretty dire in terms of cash flow. So just be careful. There are ways of dealing with it. Extend the schedule beyond the completion date. That's not perfect because we don't know how long a project's going to be delayed for when we sign the contract. So, ideally some pretty clever wording to say, if the project's delayed, then, this is what's going to happen. I say clever wording because it needs to be fairly comprehensive. The next case, so the second bullet point, is 2017 case of Kersfield and Bray Slaughter. And in this case, the court said that the notices must be served on time. Well, we've already looked at that, and in accordance with the contract. So check the provisions for serving notices in particular. Next case down, again 2017. In this case, the court said the form of the interim payment application is important, and also what you call it. So this is what I was talking about earlier. It's potentially going to become a notice, so don't try and hide what it is. Be very clear, because the risk is if you try and hide what it is, so I don't know, you put it in a different form to the form you normally use, you don't call it an interim payment application, and then you're trying to argue that you're entitled to a smash and grab on it because there's been no payment or pay less notice. The chances are the courts will say, no, it's not valid because it's not clear enough. The purpose of a notice is to be super clear as to what it is, so that the paying party isn't deceived into thinking, oh, this isn't the normal form of IPA, or it doesn't say it's an IPA, the others all previously have. Right, we don't need to respond to it. It's just not worth going there. And then this 2021 case, the final bullet point. In this case, there was a sort of mixture of, and we see this quite a lot, we're going to pay this on account, and we are going to have another think about it, once we've submitted this notice. So this was a payment notice, and we're going to update the payment notice later on. So what they did was they served a second payment notice later on. Well, that was outside of the payment notice timescales. So we know if you don't comply with the timescales, it's not valid. So the second one was invalid because it was outside of the timescales. The first one was held to be invalid because it didn't state the basis of calculation, because the court said it's not a valid basis of calculation if you say, I'm going to pay this on account because I don't really know what it's worth, or you say, I'm just going to guess this and give you something better later on, because that's not the basis of calculation. So it's quite strict, and quite an interesting case. More relevant to, I suppose, contractors in subcontract situation. Be careful of putting things on account, and be careful of saying I'm going to update this later on. And also, I suppose if you're on a receiving end of a payment notice that does that, there's huge potential there that you might be able to claim a smash and grab, and claim that that notice is invalid, and therefore the interim payment application prevails, and that is the sum that's payable. So if we can move on to the next slide, please, Jen. Okay, so bang up to date here, 2023 case. Now, so the second paragraph here, so this went to the Court of Appeals. This is serious stuff. The issue here was that, unfortunately, the contract said two different things. There was a discrepancy between the standard terms and the specifically negotiated terms. So that's not a great start. What the contract said, what the court said was that they opted to go for what was in the specifically negotiated terms. It's not massively helpful, because what you do want with these provisions is to understand, what exactly applies. You don't want to be trying to work out when you need to serve your notices or your interim payment application, and for there to be discrepant terms in the contract. The court also looked at 4 bullet points here. One was that previously the paying party had made a payment when the application for payment had clearly been submitted late. Court said not interested in that. That's not going to, determine how this application is dealt with. But what the court did say was that in this case, the application that was the subject, the interim payment application that was the subject of the smash and grab, was in the eyes of the court held to have been affirmed as being valid by the paying party, and that was because for 8 months they treated it as if it was valid, and it was only when the matter went to adjudication that they suddenly said this isn't valid. So the lesson to be learned there is that if, whichever party you are, you consider that the other party is submitting a notice that isn't valid, and that includes the IPA, then you need to be saying, I don't think it's valid, but without prejudice to that. So if, for example, you think that an IPA isn't valid, my advice would always be to still submit a payment notice in response to it, but to say, I don't think it's valid, so this payment notice that I set out below is without prejudice to that point, and I reserve my position that it isn't valid. But if it is, then this is my position as to what should be paid. Otherwise, you might find that you take the view it's not valid, you don't submit any, any notices yourself, and an adjudicator says, well, actually the IPA was valid. You haven't submitted your notices, therefore clear-cut smash and grab. The party doing the work is entitled to the sums that they've claimed. So if we can move on to the next slide, please. Yep, so this one, the two main points here are this clause 7.4.3. This is a fairly common provision where amendments are put into contracts or a bespoke contract saying that with your interim payment application, not only do you need to state the basis of calculation and the amount due, but we also want this whole raft of information, which is the arrows here. So second arrow is, photographs. Third one is insurance renewals. Now the contractor here argued that there'd been no payment notice or pay less notice, so it was entitled to its application for payment in full. Lidl said, you've not complied with this 7.4.3, you've not submitted the photos or, the evidence of your insurance, so your application for payment is not valid, so it's irrelevant, it basically goes in the bin. The court said no. So if we can just move on to the next slide, Jen, please. The court said no, that's not the case. It's issue 1, because it said the clause wasn't drafted as a clear condition precedent to the validity of the interim payment process. And then the final point, I'm not going to cover issue 2 because it was discrete to that contract, but the final point is this issue 3 that I've already talked about, where the final date for payment in the contract was related to the date on which the party applying for payment, the contractor, submitted a valid invoice following the payment notice. And the court said that's not valid because, as we've seen, the final date for payment has to be pegged to the due date. It can't be pegged to something else. And in this case, they tried to peg it in the contract to a valid VAT invoice. So, you know, I don't know what this recent case law to me just says this has all got very convoluted and quite difficult for construction. I mean, sometimes it's quite difficult for the lawyers to deal with, but the intention of the act wasn't that, you know, everybody had to get their lawyers to administer this. But, you know, it feels like it's getting, you know, quite convoluted and quite difficult to deal with. So if we can have the next slide. Yeah, I'm not going to deal with that one. And the next slide, I think, yeah, we've covered that. So if we can deal, yeah, we've covered all of that. So I think we're up to any questions. Yes. So